I'm Jamie Gillespie, and I'm the General Manager of our Online Dispute Resolution Department at Tyler Technologies. And today we're going to talk a little bit about what online dispute resolution is, and we're also going to hear from our panelists up here, which are going to give you some info on the perspectives that they have, because we have a judge, we have a court administrator, and we have a mediation manager. So today you should be able to hear some information from all different roles within the court. So I'm going to get started just by talking a little bit about what online dispute resolution is. And I think everyone has seen this definition or probably heard what the definition is, but we'll just talk about this and then we'll get started with the panelists. So just to get started, it is court-related. Online dispute resolution is just a public-facing digital space where the parties can go in and talk to each other and try to resolve their dispute or their case. But there's three key components that are important in order for this to be considered ODR. So the first one is that it needs to be exclusively online. So the process needs to be online from the beginning all the way through the end. It needs to be designed to assist the litigants resolving the dispute. So it really needs to be focused around those parties and their ability to resolve their disputes. And then the last thing, it needs to be either hosted or supported by the judicial branch. And that really just means that it shouldn't be a third-party system that's branded such as a third-party system. It really needs to be something that is coming from the court and allows people to feel like they are interacting with the court. So you don't necessarily, as a jurisdiction, have to host it, but you do need to make it look like it is something that is supported by the judicial branch. So those are the components there. So now, just to kind of get started on our panelists here, we are going to first have Judge Jane Levy get up, and she's going to talk to us a little bit about the state of New Mexico.
Good morning. So I am a judge in Albuquerque, New Mexico. My name is Jane Levy, and I have primarily, my docket is family law cases. However, the area where we have started using online dispute resolution is with debt and money due cases. Those are cases, the way that we do it, where there is one party on either side. Generally speaking, these are collections cases, sometimes thought of as sort of the breach of contract involving money only. And those are the cases that we're focusing on. The purpose is because we have a giant state. We are the 5th largest state in the country, and much of our state is rural. So that's a hard word to say, by the way, rural. So in any case, it's not very populated, and we have most of our population along what we call the I-25 corridor, which runs right in the middle of the state. So what we were facing is what I would call attorney/mediator deserts, areas where we have very few attorneys, very few mediators, but we do have a lot of people who have serious debt issues. We are not an extremely wealthy state, and so we have quite a few debt and money due cases and people who are looking to enter into reasonable payment plans and resolve their cases without obtaining a judgment. So that was the focus in starting with debt and money due cases for ODR. We have had a lot of success, which we'll talk about, but we're very early days. So New Mexico has started this process, and we are hoping to expand it and move forward. Thank you.
Okay, now we have Tim Ezell, who's going to talk to us from Fulton County, Atlanta.
Good morning. My name is Tim Ezell, and I'm the Director of Court Support and Administration for Fulton County Magistrate Court, where the Honorable Cassandra Kurt serves as our Chief Judge. Fulton County, Georgia's population consists of 1.04 million citizens. We are a limited jurisdiction court, and we have a variety of cases that range from first appearance to small claims cases to landlord tenant to child abandonment, garnishments, and more. Our bench consists of 9 full-time judges and 21 part-time judges. We handle anywhere from 80,000 to 100,000 cases a year, and the majority of our citizens, or our litigants, are self-represented, which is why we decided that we wanted to pursue implementing Modria, because we started with our small claims case type, and what we heard from our small claims litigants were that they were having trouble coming to the court with, whether it was dealing with car issues, childcare issues, and things of that nature. And so those obstacles, we said, let's find something that will give us the opportunity to allow them to resolve their disputes from home. And so we could reduce the number of default judgments that were being issued and cases being dismissed, which is why we decided to pursue the Modria system. Thank you.
Okay, and lastly, we have Linda Sayegh, who's from here in Clark County, Nevada. She is the mediation manager at the Family Mediation Center.
Good morning. I'm the manager of the Family Mediation Center, as Jamie had stated, and Clark County has a huge population of over 2.1 million, and people keep moving. And of course, in a couple years, we'll have 3 more additional family court judges. We currently have 20. So in Clark County, mediation is mandatory for child custody issues, and we don't mediate the financial issues in our office. So what we are negotiating is mainly the custody, the scheduling, how the kids are going to go between the parties. So I lost my train of thought, I'm sorry. So with the mediation, because it is mandatory, our caseload is huge. So for example, last year we had 3,900 cases that were just mandatory mediation. And we do offer remediation, and parties are oftentimes coming back. So the online dispute resolution has really assisted us in assisting parties and giving them a little more access to justice. So, thank you.
Thank you. All right. Okay, so now what we're going to do is I'm going to ask some questions, and so we will get their perspectives on some specific questions that we have. So I'll hand that to you. All right, so the first question, and we might have talked about this a little bit as you were introducing yourself, but Judge Levy, why don't you start? What are the reasons that you wanted to do this in your jurisdiction, and maybe not necessarily you, but the entire group?
Okay, now I think it's on now. Okay. So first of all, I should explain, New Mexico, we have a unified judiciary. So when we decide to do a project, usually it is something that we're looking to roll out statewide. And that's part of why we thought that ODR would be helpful. Modria presents an opportunity for people to have access to mediators and to resolve cases even if they live 80 miles from the courthouse. So that was the reason why we were interested in it. We were also interested in it because we need as well, this was mentioned, that to reduce defaults and to encourage people to participate in their case. A lot of times in debt and money due cases, defendants do think that they owe the funds, but they don't want to participate, and so we were trying to use something that would perhaps lower the entry to the court and actually have people participate beyond getting the complaint and being worried about the fact that now they've been sued. To that end, one of the things that we've done to promote people using ODR and why we thought this would be important is we were sending out blank answer forms and a little instruction list saying, welcome to online dispute resolution. Your case has been selected to participate in this. Please file an answer and we can help you participate in the court system. So really this was a focus on our part in creating an access to justice model, something that helped people resolve their cases from their living rooms no matter where they are in the entire state. And also connecting people with mediators. We do have voluntary mediators right now that are working with us. So even if you are in a small city, we got somebody in Wagon Mound, which is a real city, Wagon Mound, New Mexico, who is trying to resolve their case. They can have access to a mediator in Albuquerque. So that was part of our purpose.
Okay. Tim, how about you? What was the reason that you wanted to do this?
So we first started off with a backlog of small claims cases with like 30,000 that were still pending and that needed to actually be touched by a judge. So we were looking for a way to resolve that issue and get litigants quicker to trial. So when we implemented it for our small claims cases, we still schedule it for court, but they have that 30-day window to actually try to reach a resolution on their own. And when we encourage them, because it's better for you all or the litigants to be able to reach their own resolution compared to having to come before a judge, and you may get a ruling that you don't agree with. So we were really looking to reduce our trial calendar size and also give the parties a chance to have a platform where they can have the discussion amongst themselves as well.
Okay, thank you. And Linda, same question for you.
So at the time that online dispute resolution, we decided to take it on as a pilot program with our presiding judge and 3 of the departments, because at the Family Mediation Center, our in-person appointment, you were about 2 months out for an initial appointment. So with the pilot program, initially 3 of the departments took it on and we saw success, and we rolled it out this January to all of our other family court judges and their departments. And what we were finding is, before we rolled it out in January, actually towards the fall, some of the other judges were approaching and they wanted to be a part of this because they were hearing about it. So me and the presiding and the court administrator decided, let's roll it out. They want to be a part of it. We're seeing success. So much so to where now with the Family Mediation Center, when parties are referred to mediation, we sign them up for the online dispute resolution as long as both parties speak English, and we have email addresses, and they can start that same day we receive the referral. And then we also do schedule an in-person appointment now 3 weeks out. So it has really helped us because they're not only starting the process ahead of time, some are resolving on their own where they don't need to come in person, and those that still need to come in, maybe they haven't resolved all the main 5 areas that we look at, they're coming in with that mindset of, okay, we know what mediation is, let's stay focused, and more so, there's a couple areas maybe they have resolved, so you can just focus on what they haven't resolved. So our appointment time, instead of being 2 hours in duration, is now 1 hour in duration. So we've changed the way we do things a lot, and it's benefited us and the parties.
Okay, thank you. All right. How have you accomplished the task of gaining the buy-in from some of the additional stakeholders, such as your judges, attorneys, and even your mediators, to participate in this?
Well, for us, what we did is we started by gathering a group of mediators that already help us in cases like debt and money due cases in our courts. So we have a pool of volunteer mediators that work statewide through our administrative office of the courts. And we had a training for them, put together an entire training and invited mediators to participate. It was actually quite an easy buy-in. They were very excited. We said things like, we really don't know what we're doing, but we hope that you'll help us and we can work together to create an online portal for you to mediate, because it's, let me see if I can say this word, asynchronous. In other words, oh my gosh, I haven't had that much coffee. I'm so proud of that. Thank you very much. That means that people can make offers back and forth, and the mediator can assist those folks, but they are doing it when they have time. And so it is not necessarily back and forth immediate. So the mediators were interested in this model. This is very different from the way that they focus, and they were excited. For our attorneys, the plaintiffs' attorneys, we met with them and walked through what it looks like. How does our version of Modria work? What do you do? Why are we doing this? And we had a lot of questions, but they were more interested once we had a sit down and a presentation to participate. Obviously, there are always concerns. The way our model works is that you end with a settlement agreement, not a judgment, and that was the biggest issue for those folks, because they really wanted to, they usually settle cases with a judgment, and so they wanted that immediately. So that was the one tripping point for them. But they were responsive and interested in using the model that we had created. So with Tyler, obviously. And then the defendants' attorneys that represent a lot of consumer groups were hesitant, but we've created a dialogue and in fact improved, I think, the way that our system works by asking Tyler to make adjustments here and there to address some of the concerns that were reasonable that were raised by the defense bar regarding debt money due cases. And Tyler was very willing to help us. So that's been hugely helpful. And we just continue to present. Honestly, I go places and talk to different bar associations. We have our judges throughout. We have 3 pilot courts going right now. And the judges in those 3 pilots talk to the media. We had a huge media rollout, and that was very helpful, I think, in just getting the word out and making people not be so hesitant, because I think a lot of folks worry that, this is sort of like hell coming to take your job or something, and so we were trying to get folks involved. And the judges actually had no resistance. They were very excited because they know how big their dockets are and how helpful it could be.
Okay, thank you. Tim?
So we started with our chief judge. So luckily for us, our chief judge, Judge Kurt, actually was the one who was spearheading it for our court. And so once we got that, once she gave this is something I'm interested in, we rolled out stakeholders meetings, and we met some resistance with our mediation staff because they were worried about maintaining the mediation process and confidentiality and screenshots and things of that nature. But during that stakeholders meetings, and we had the clerk's office, we've had our ADR office, we had the mediation team, we had our Modria representatives, and we really worked through each of those issues to make sure that we could come up with something that everyone at the table was comfortable with. And as we worked through those processes, it actually gave us other insight, because when you're looking at it from like a court administrator perspective, I'm not thinking from the mediation perspective or the judge's perspective. I'm thinking for the administrative and the flow. And so we really were able to tweak and hone in on some of those processes and ensuring that we maintain the confidentiality that made it necessary for everyone to be willing to participate in the process.
Okay. All right, Linda, how about to you? How did you get buy-in from your stakeholders?
Well, I mentioned some of it was pretty simple with the judges, and our court executive administrator was very supportive and brought this on. So we really didn't have an issue with the judges because it improved our appointment time, which in turn still doesn't necessarily push out their return court times. So if our calendars are looking good, their calendars are looking good. And they were seeing success with it. So on the judge's end, it was very simple. With the mediators and the staff, we did have a training. Initially, we had 3 mediators when we were doing it as a pilot that were each assigned to each department. And when we decided to roll it out about 2 months prior to us rolling it out to all the other departments and the judges, the mediation staff, we held a training and we worked with them, and a lot of it initially was that fear of the unknown, so they don't really picture it, see what it looks like. So once they get into it, and we were able to create some test cases so they can kind of play with it, that definitely helped them. And then they started seeing the success and seeing what people are agreeing on, or hey, I don't have an appointment today because they resolved, or we just need to work on one area. So they have majority of it drafted, so their appointments are going faster. So, and as far as attorneys, I did do a presentation with the legal aid just so they're aware. So a lot of it is, like they're saying, just getting the word out, because a lot of it is the unknown. And we still do, like we always notify our parties, whether they're in person or online, that they always have that option to review their plan with the attorney. So nothing's changed in that respect.
Okay, thank you. All right. From your perspective, do you think this is more focused for self-represented litigants or litigants that are represented, or does it matter?
I think it doesn't really matter. Obviously, maybe not obviously, but a lot of debt money due cases have self-represented litigants on at least one side, generally the defendant side. So there's a real reason to have an even playing field, which I think that Modria helps to provide, because you're really just communicating with the platform itself. But it works well when we have attorneys as well. So I think that it's friendly for everybody to use, and that was part of the process of picking out something that would work no matter who is trying to engage in it. The way that our system works, though, is that we don't send invitations to parties who are represented. It's their attorney who's negotiating for them and signing, saying, by signing here, you're signing as the attorney for the party. So it works the same way as it does generally in face-to-face negotiation, but we've had a lot of success using attorney participation as well as self-represented litigants.
Okay, Tim?
Well, in our pilot project, we're focusing only on self-represented litigants, but it gives them a platform to actually guide through the process. So it gives you a place where you can say your demands, your concerns, you can provide supporting evidence, and then what is really reasonable for you and what you're actually looking for. So I think it kind of guides them always through the court process without actually having to come into the court.
Do you think that, I'm going to throw you a little loop here, but do you think that's something that they would have understood kind of how to do if it wasn't for that, or do they just go into court and follow whatever the judge says?
Well, as a former clerk, I would tell you that they go in and they follow whatever the judge says. So what we used to face in the clerk's office is something where you're constantly coming in and saying, how do I do this? What am I looking for? And similar to like the guide and file system, the Modria system actually gives them a platform because it actually says, what happened? Do you have any evidence? What are you looking for? Will you take a payment plan? And it actually guides them through. So when you actually are sending it to the other side can say, no, that didn't happen. No, I won't take your payment plan. This is the amount I'm looking for. And it gives them that dialogue to go back and forth and the option to even include a mediator if we hit an impasse and we're unable to reach a decision. Then, hey, let's bring someone else in to say, hey, I need some help because we're not speaking the same language. Can you help get us on the same page? All while working towards your trial date. So you either get a chance to do it on your own, but you're still not losing your space and having your trial being heard in our process.
Okay, thanks. So Linda, for you, same thing about, do you think it's more focused on the self-represented litigant or someone that's represented?
I'd say there's really no exception. The focus is both in our jurisdiction because mediation is mandatory. So we have parties, we don't distinguish. So whether they're represented or not, they're using the online dispute resolution once we receive a referral for mediation. So we do find that if they have an attorney or if they are in pro se representing themselves, they're still resolving. Tim was saying, if they happen to get stuck or they need a mediator, they can always request it and the mediator will still assist them. No different than if it was in person. But whether they have an attorney or they're representing themselves or one party has an attorney, the other does not, we don't distinguish, and I still see it as helping all those parties.
Okay, thank you. All right, Judge Levy, how important do you feel that the integration is, whether it's with your case management system or an e-filing system on your success?
Well, it's certainly helpful to have an integration system. One of the things that our Chief Justice Nakamura, one of the interests that she had is if we were going to pick a system that would easily blend with the online filing system that we have, so that once parties come to a settlement agreement, it populates in Modria and it just slides right over into the online filing system, and then we have a closing code that goes with that. So that was the concept of why we would pick that kind of a program. Mm-hmm. It is helpful to have that. I do think that part of it is also that you can have, there's a little ADR tab on our Odyssey system, so we can see if the parties have been referred to that kind of system, and we can see when it's closed. So it's really easy to use, and anybody can use it. And I would consider myself a moderately Luddite, and I can use it. So it's pretty straightforward. And I think that's the benefit of having something that just seamlessly works with your online dispute resolution system.
Okay, thank you.
And I would say similar for us because ours is integrated as well. And what we were looking for is making sure that we had a process that didn't add more work onto the clerk's office. So once they've vetted and they've actually saw which cases are actually eligible, it's adding a docket code, and that triggers the process to start. The parties get the email addresses, and whether they actually reach a resolution, time expires, or they're unable to reach a resolution, it actually files a document into our e-filing system, and the clerks will pick up their normal process in reviewing it and accepting that document. So it'll either let you know, hey, you reached the agreement, you don't have to come to court. Hey, your time has expired, please report to your court date. or hey, you tried and it didn't work, you should still report to court. So you're not losing your place in line, and you're still getting a chance to actually resolve it from home, and it's not making extra work. It's just literally adding a code that says case referred. And I think something that was great for us is for the clerk's call center area is being able to actually see if that case is referred. So that ADR tab in Odyssey is crucial, because you can actually see this case is there, and then someone's actually calling and inquire, what is this email? Then you actually can say, yes, this is something that you've been referred to, and it's a court process.
Okay. We'll do another question real quick so you can come over here. What extra work has been created for your staff because of this, or has there been any?
Well, I think there hasn't been a lot of extra work. As you were saying, it's one of those things that when it comes in, when a answer is filed, then the clerks just enter the code that it goes to Modria. So it's just a code itself, and that refers it, and the system just starts from there. Once the case is either resolved, or if it's not resolved, then it comes back into the system and another code is entered, and we're just back in the docket. So it hasn't added a lot. We did go and do a full training. Again, our Chief Justice was promoting this process, and she made sure that we went to all of the courts and talked to them and trained all of our clerks. But the clerks were pretty open to this process, and we haven't heard any feedback that was negative about participating with this. In fact, everybody's been positive. They're just interested in tracking what's happening. Right. So it's been very seamless, and it did not add much in the way of work.
Okay. Tim, did it add any work for your staff?
Our process is extremely similar, so the same steps and the same adding the codes. That was only additional, and actually being able just to source through, so the person who's actually in the calendar unit, making sure that they identify that they're both pro se parties, and that they both provided email addresses, and then actually starting the process from there.
Okay. All right, Linda, we can go to Linda now. Did it change or add any additional work on your staff?
I wouldn't say so much as additional work, because although we haven't integrated yet because we were first, to initiate it in ODR takes just like a quick minute, because you're just inputting the information. So we are working on doing that. And really it's helped our office in a way to where our appointment times are cut in half, and it's not additional work for the mediators, because they're getting email notifications when parties are completing or sending a message, and so they're doing it no different than if they have a phone message or if they have an email from a party. They're responding in between their sessions, and actually, like I said, they're having appointments that are being canceled because parties are resolving. So in a way, what we've come up with by looking at having done this a little over a year is, with the online dispute resolution, we figure it's the equivalent of a full-time mediator. So in a way, we have another mediator on staff amongst online dispute resolutions.
Okay, thanks. Okay. Do you see this as more of an online court or online mediation, or a little bit of both?
I would say a little bit of both. I think that it depends on the perspective of the people that are using it. I think that from the feedback that I've received, the plaintiff attorneys see it as being more of an online mediation tool, because they're just used to negotiating back and forth and entering what they want and why they want that payment and what dates they need it by. The defendants, on the other hand, it comes with a court seal. So the email comes out, and we're trying to promote people to participate in it. And so I think that it's a little bit different of a connection, because if you're a self-represented litigant, I think anything that comes from the courthouse feels like a little bit like court, but it's very easy to use. So our hope is that the impression that is left with the defendants is that this was a simple court process, and that it was not intimidating, and perhaps that bleeds over into being able to come into the courthouse. But I really do think it has more to do with the perspective of the people using it. From our perspective, this is a mediation tool. It doesn't have we don't adjudicate anything in this process. That you still get, just like Tim was saying, you still get your court date if you don't settle, or if you only settle part of the case. So it's not a substitute for coming into court if you need an adjudication, but it is an opportunity to try and negotiate and settle.
Okay, thanks.
I agree. I think it could be a little bit of both, because I think it's an online court process for those who aren't used to court processes, because it's guiding you through, it's telling you, give me your demands, give me your dates, give me your information, give me your background, and then you can go back and forth through the court process, similar to a court process, up until you feel like, okay, I need to get a mediator involved. And then at that point, you actually start engaging in the mediation process, because you can have private caucuses and have separate conversations, and then come back, and all in the app, to come back and have those discussions to see if you can really reach a resolution. So I think it can be depending on what perspective that you're looking from, it could either be an online court process if you're not familiar with the court system, or it could be an online mediation if you're actually engaging a mediator and getting them involved as well.
Okay, thanks. Linda?
I'd say I see it more as an online mediation, and a lot of the reasoning is aside from the cues that we have. So we do give them guidelines, introduction, kind of let them know what the expectations are, and we do remind them that just let us know what your proposal is. No different than if they were in our office. So that history of who did whom wrong, we don't necessarily want to know. So as they're doing it and completing their proposals on their own, there's reminders throughout, what do you propose, and some drop downs, and almost like a multiple choice throughout the system. So we're guiding them more on the future oriented of what are your proposals for the schedule and the time for your children. When the mediator is involved, it's no different than if they were in person. They know to keep them focused on the future proposals, because going back and rehashing the past, there's unfortunately not much you can change. So for us, it is a mediation of seeing where mom is, where dad is, and how far apart they are. Like Tim was saying, the mediator can either speak with them conjointly, there's a chat section, or if you need to speak with them individually, which a lot of the mediators find to be helpful, and a lot of them use that more often, is to kind of caucus with them, speak with them individually, because you see what each party's proposing, so then you can make suggestions and see really how much of it is negotiable, or are they willing to accept something more in the middle. So for us, we're using it more as an online mediation.
Okay, thank you. Judge Levy, do you believe that ODR has helped expand access to parties that would not have otherwise had the ability to interact with the judicial system?
Well, we're early in our program, but I think that it has and it will. The focus of ODR, the way that we're doing this, is that essentially when a complaint comes in, we wait for the answer right now. When the answer is filed, then everybody's referred to ODR. We would love to get to the point where we didn't wait for answers and everybody was slotted into ODR, but we need to get email addresses from everybody. But right now, we do think that it is actually promoting people to participate, because when the summons goes out, we have a letter that we work very hard on. Mateo Page is the head of our ADR system for our administrative office of the courts, and he put together a letter that describes, I mentioned it earlier, how why it is that this case has been selected for ODR, and that you're going to be participating in online dispute resolution, but you need to file an answer. Here's a blank answer form. If you don't file an answer, you may have a default entered against you, and then off we go to the garnishment phase. So we are seeing that people may be participating actually more, because they are, first of all, getting something from the court that looks a little bit more personal than a summons does, and it also encourages folks to participate in their cases. We have, depending on where you are in the state, huge default rates, especially in our Four Corners area, which is the Navajo reservation, and quite a few debt and money due cases. So our hope is that more and more people are going to be participating in this process. And by participating, they may see that they have perhaps stopped a default entry from happening, and certainly maybe resolve their case with more fair terms, and perhaps with the appropriate interest rate attached. There's a lot of protections that we built into the Modria system to try and make sure that what they're getting is a correct result that comports with the law.
Okay. So Tim, do you think that this has helped expand access to the parties that may not have had access before?
Definitely, and I think that's why we started with our small claims cases, because we were looking at our default judgments and number of cases being dismissed, and we run anywhere on status calendars, we were running 150 to 300 cases, and dismissing, the majority of those cases were being dismissed for parties not showing up. So when we actually implemented Modry, it gives them a chance to actually address those issues, because you can work on it from home, you can work on it in your phone, you can work on it anywhere that's convenient, and then throughout the day. It doesn't have to normally necessarily be during business hours, where you can actually say, hey, let me take a moment on my lunch break to respond and say what I'm interested in and upload my documents. As long as you have access to a smartphone or your computer, it actually opened it up. So it really addressed a big issue for us, and is helping towards reducing that default rate in those cases being dismissed in our county.
Okay. So Linda, how about for you?
I'd say it's helped the parties get a little, not only faster, but easier access to justice, because aside from, a lot of parties don't necessarily have a computer, but a lot of people have mobile phones. So we're seeing, I'd say, probably almost more than close to 70% of the plaintiffs have initiated and started and are participating since we've made it mobile friendly. So what we find a lot of times in Clark County is, because of the casino industry, nobody really works a normal schedule. You have all sorts of shifts. So sometimes, I mean, people can't necessarily get the day off. The main thing with casinos, just for example, is they're on a point system. So if they're running late, they need to take time off. Aside from taking time off for court, if they're needing to take time off for their appointment, they're getting dinged. So with the online dispute resolution, a lot of parties you find don't necessarily want to have to come in. They'd rather get it resolved and done and do it from the comfort of their home. So rather than risk losing their job or getting in trouble at work, sometimes it's as simple as, I don't have gas money, or I was sleeping, or I don't have childcare. So there's a lot of various reasons, but what we found here in Clark County is a lot of those people that are settling, they're settling on the weekend or after our normal business hours. So that's really giving parties in access to justice.
Linda, I can't remember that exact number, but isn't it around 80% of y'all's settlements are after hours or on weekends?
Yes, and I think the quickest settlement was less than 2 days.
Yes. Mm-hmm. Okay. So one of the things that we've that's been mentioned quite a few times here is about the email address and getting the parties engaged. So what kind of ideas do you have that might help to increase the adoption of ODR, whether it's, you know, getting an email address or getting the parties to engage once you have that?
Well, I do think that one of the things that I think that Tyler's been looking at this is that eventually moving to also allowing us to use text as a way to do this. And we use text right now for getting people to show up to court dates. So that might be helpful too, because there is a certain segment of the population, I'm going to call them younger than I am, who don't, when I say email address, they kind of roll their eyes or like, oh, I don't have one. So, but that's how everybody younger than me sounds. But they, generally speaking, some people are a little worried about giving their email addresses out. In family court where I am, we get people's email addresses anyway and have been able to promote that just over time. So I think part of this is time, getting people used to the fact that as part of, you know, you give your phone number, you give your email address, and we all have that email address that we use for like all the shopping that we do. You can use that for the court. It doesn't matter as long as you're actually seeing it. What we have done though is Tyler did give us a whole bunch of cards to hand out to folks. So when people do come into file, we hand them information about the fact that they are going to need to give us their email address, and it's okay. We're going to send them an email and to make sure they check their spam folder. And those folks, generally speaking, have been, once they read and they see it's official, have been willing to give out their email addresses. But it's also just making sure the clerks are trained to promote, to ask for that kind of information, make sure the entire information page is filled out. And so that's just new for us. So I think some of it's just going to take over time. But as far as promoting it, I think part of it is just telling folks, just like your phone number, your email address, and trying to get people used to that as a concept that this is the way that we, in a connected world, we communicate. And frankly, anytime you go anywhere, I know to check in here, I had to give, I'm not sure, like everything, birth weight, I'm not sure, but I definitely had to give my email address. And so there's a lot of information that I think folks are getting more and more used to giving.
Okay.
I think similar for us, but what we did was we started with updating our form. So we updated our statement of claim, which is the initial filing, and we updated our answer form. But I think it goes hand in hand with being able to make sure, because we partner heavily with our clerks because they are the front-facing people. They're fielding those calls. They're getting those thousands and thousands of people are coming in, and if they're not aware or not on board with actually promoting it, then we're missing opportunities, because you see the line on the form that says email address, but if I don't understand the reason why I'm putting my email address on here, then I won't. And so you want to actually increase it, and you want to make sure that the people who are actually dealing directly with the customers are on board with it, because at the end of the day, it's reducing our calendar times, it's speeding up our processes, and allowing our court to be completely more efficient. So it's about getting all the parties involved and making sure everyone understands how significant, especially similar with the text messaging, because we're using text messaging as well, is that why I'm asking for your cell phone number and why you're giving that information. So the more you put it on your website, the more you do put the letters in your mailings and things like that, you're promoting it and you're actually encouraging people to try to resolve it on their own.
Okay, thanks. Linda?
So similar, we also have a handout that we give to parties and let them know ahead of time, okay, we have your email address, you're going to receive something today. So they know to expect it, and we're also giving them a handout of, just in case if they need it, tech support information, but it kind of breaks it down and lets them know, aside from your handout on how ODR works, you also have your in-person appointment 3 weeks out. So if you haven't resolved it, then you're coming in person. We've always had our email address as part of our forms, and now our family court has made it part of the cover sheet recently, so somebody's always writing down an email address, so that part's pretty simple now. As far as the fees for mediation, one of the other ways that we do kind of benefit the parties if they are able to resolve on their own is the fees reduced if they're able to resolve using the online dispute resolution without the mediator. So whereas if you come in person, the mediation fee can be anywhere from $50 to $200 in person, depending on your income. If you resolve online on your own, it's $35. So especially those parties that maybe just need something in writing or maybe just need a little bit of guidance, this helps them, it benefits them as well. So if the mediator assists them, it's slightly more, it's still $50, which is just the minimum. So we have incentives in a way to not only help parties financially, but also you don't have to miss work, you don't have to worry about getting childcare. So it's not really becoming an issue for us, and they like it.
Okay. So, Judge Levy, how are you measuring success with your ODR program?
The way we're doing it right now is our judicial information team is pulling from the all of the pilot courts the number of cases that were referred, whether the plaintiff participated, and if so, if the defendant participated, and if so, if they resolved their case or if they were unable to resolve. So we're pulling those numbers actively and monitoring. We're also seeing how many cases are requesting mediators. The way our system works is that it's a dual request. You don't have to do it this way, but it means that if one party requests a mediator, the other party must agree to use the mediator. And so that dual request, we monitor that as well.
Okay.
So we see, and we're pulling those numbers constantly to see what the success is. We have right now looked to see if there are some cases that, because I heard from plaintiffs' attorneys that they said, we're actually using your system to come to an agreement, but I really want that judgment. So as soon as we get to that bottom, I chat with the other side and say, okay, cool, can you come into my office and sign? Or I'm gonna send you this, I need you to sign on to the judgment. So we don't have a way of capturing that right now. We have ideas about how to address that, because it's still, as far as I'm concerned, that's a pretty good result, because they're resolving those cases very quickly when they're using it.
I'm going to have you answer another question real quick about that. Is there a reason why you chose to do a settlement agreement versus a judgment through the ODR system?
We did. The reason we did that was because we were hoping that would promote defendants participating. One of the benefits that they get in some of our limited jurisdiction courts is that if they do settle their cases, that it is not reduced to a judgment immediately, but instead it becomes a settlement agreement. And we have, through our system, created a rule that says that the case remains while we close it. So our judges are very happy because the case is closed, but the actual file remains open in the sense that if they ever need to come back the next 5 years to enforce that, if there is a breach of the settlement agreement, then they don't have to file another filing fee. They just say we need to enforce, and at that point it becomes a judgment. So that was sort of an enticement to participate for the defendants. The downside is that the plaintiffs, like I said, are a little bit wary about the fact that they do want to have a judgment automatically. So that's why we're seeing some of the sort of sidestepping of that in some of our cases. Other cases, everybody's just resolving, settlement agreement, good to go.
Okay, thanks. All right, so Tim, how do you measure success?
So we do the same thing. We're constantly monitoring those settlement agreement rates. Are they asking for mediators, and are they tracking it? But one thing that we're working on is we're actually working on building a survey that will allow us to really capture feedback from everyone that's involved in the process to see what enhancements we can make to make sure that we're actually helping people utilize the system compared to having to come to court. So we track those settlement rates, and we're still in our pilot phase. So we're tracking those and looking at those numbers, but we're also planning on rolling out a survey that'll allow everyone to participate, to give us real feedback that we can use to continue to enhance and build as we work towards other case types.
Okay, thanks. Linda?
So similar, of course, we were able to track and see how many parties are settling on their own using the online dispute resolution. So the metrics will break down for you how many parties have a plan and didn't need to come in. But the other way that we measure success, because mediation is mandatory here, is aside from those that settle on their own, they sign the plan online, they never have to come in, is of course they have that option to settle with a mediator, is really when they do come in for their mediation appointment, a lot of times a lot of those main areas are resolved. So we're already a step ahead by the time they come to their in-person appointment. So success isn't just how many are actually settling and resolving, it's also you're a step ahead. We know there's maybe only a few areas that we need to work on, and if nothing else, the mediator can already start the process. So when they come in, you're just picking up where you left off.
Okay. So besides the case types that you're currently implementing, what do you kind of see next for your jurisdictions, and maybe why?
Well, our Supreme Court has been hugely helpful in promoting this process and has been very supportive of adopting ODR. Like I said, our Chief Justice is the one who really drives innovation in our state as far as the judiciary goes, and she's excited about looking at the next area. And one of the areas that we've identified is traffic. Right now, we want to expand and are in fact investigating. Our Chief Information Officer, Mr. Wesson, is, I think, wandering around the state right now trying to figure out how we can roll out traffic. And what we're talking about when I say traffic are your speeding tickets, your registration, not driving with your driver's license, those kinds of things, and being able to resolve that immediately online. That would not need the use of any actual mediators. Instead, it would be modifying the tickets to include that if you want to participate in an online negotiation, then go to this website and then put that information in. So that's kind of what we're looking at if we're going to do something like a traffic as the next area. I mean, honestly, this is just personal. I started this whole process because I really wanted to pay like parking tickets this way and do the registration thing. So this has been my evil plan all along, was to sit in my living room.
A little
and
personal.
Yeah. So I just, we're a big state and they get real picky about that speeding thing. So I just want to pay online and get it over with. So.
We're currently looking at doing landlord tenant next. So we do anywhere from 40,000 to 45,000 landlord tenant cases, and the majority of those cases that are actually scheduled for hearings are referred to mediation on site. before they actually go to see a judge. So when they actually come in, the defendant files their answer, they're actually coming in, and if they've given a sufficient answer or a sufficient reason, they're actually referred to our mediation staff first. And then if they're unable to reach, and they hit an impasse, they're unable to reach an agreement, then we direct them to a court hearing. So we're looking to put a bridge in between there to actually allow them, before they're actually coming in for their hearing, the opportunity to mediate and reach an agreement so they don't have to come to court, and that we can handle that extremely heavy volume calendar size. So that's what we're looking at exploring next.
Okay, thanks.
So specifically as far as where we're looking next, that I don't have an answer for you, but the possibility is really anywhere that mediation is needed and can benefit the parties, such as especially here, I mean, small claims, maybe the Neighborhood Justice Center, traffic, as Judge Levy has said. It's really anywhere where that's going to give the parties that little bit of control, maybe self-determination to where they feel like they're resolving it, but I wasn't told I had to do it, but okay, I'll deal with it just so it's over. So really, I mean, there's a lot of options out there.
Okay. All right, well, those are all the questions. So I don't know if there's questions in the audience, if anyone has any questions, or if you have any closing remarks that anyone would like to say. Anything? Okay. I don't know if there's any questions in the audience. I don't see any. Well, thank you all, and we'll be here if you have any questions. Appreciate it.